Thanks. No? Okay. Okay. All right, we'll kick it off with, excuse me, with House Bill 651. But before we do, we've got some new faces here at the table. Most importantly, to my left, our new committee secretary, Kathy Barnett. Welcome. We're happy to help. Mary Lou Morris is our committee lawyer. As a repeat performance from last year, welcome back. Rob Lafayette is our committee aide. Good to have you, Rob. And we'll see if we can break a new record for speed on House Bill 651. Representative Carter, as I understand it, the list that we're talking about in Section 1 of the bill has in the past been provided in a hard copy, and your bill simply would allow for that for that reporting to be done electronically and thereby save the cost. What kind of cost are we talking about?
The cost this current year, which it was not even done in paper form, it was done like this, this envelope. The cost was total $7,765.72, which does not even include the cost of the staff that put this together, made the copies and put them in the envelope and mailed them. That's the cost of making these and the postage on these.
Did I explain the bill pretty well?
You did very well.
Any questions for the author? Is there a motion?
Second.
Was there a question?
No.
No. There's a motion. There's a second. Any further discussion? Any amendments? I see a blinking light. There was no question? Oh, I'm sorry. Any further discussion? Hearing none. All in favor of the gentleman's motion signify by saying aye. Aye. Opposed? The ayes have it. The motion passes. Do pass. House Bill 651. Thank you, Representative Carter. Let's call House Bill 538. Chairman Rice. You should have, there's a bunch of language in here on House Bill 538. Chairman Rice, tell me what your latest substitute is so we can make sure we've got it. 2401S, LC 342401S. There is also a substitute that's going to be offered by Mr. Franklin, which is LC 342385S. There's also some proposed language that I put together in the form of an amendment, which is not numbered, but it's basically the amendment starting at line 12. Does anybody not have any of that information? Okay. We'll go ahead and work on Chairman Rice's 2401S, and then we'll get into the process there. Chairman Rice.
Thank you, Mr. Chairman, members of the committee. You heard this bill a week ago, and thank you for the opportunity to come before you again today and ask for your approval of this really small change to the code that will tighten it up and hopefully cause us to have better drivers in the state of Georgia who are going through the defensive driving course. Basically, all this does is to say that if you are in a court and you've got a situation where there's either a ticket dismissal or point reduction situation going on where there has to be a defensive driving school involved, and the court orders that, it has to be a school that's been approved, a school that's been approved to give the course by the Department of Driver Services, just like all the other schools in the state of Georgia in terms of the driving laws, driver ed, and so on and so forth. The reason for this bill is basically found in instruments like this, which comes from one of our local courts. It basically says, here's a list of driving schools and clinics you can go to take these courses. Some of these are ordered directly by the judges. Out of the 5 that I see here, only 1 is a DDS approved course. The other 4 are all over the lot. They could be from different states, different places, and they don't necessarily have the approved curriculum. Therefore, all we want is the judges to have them ordered to go to DDS approved courses.
Essentially, if a driver is going to go through some sort of pretrial diversion program,
right,
we want that course, that defensive driving course, to be a course that's sanctioned by the Department of Driver Services, as opposed to
if they order a driver improvement school,
right,
it has to be sanctioned.
Right, yeah. But I mean, because I'm going to the language of your bill, and we can, and this goes to my amendment. Really, if it's a pretrial diversion program, that's really my understanding is that is really prosecutor-driven as opposed to court-driven.
That's correct.
So it's really not a matter of, and again, we'll get into language in a second, but courts with jurisdiction that order an offender to attend a drive under a pretrial diversion program. I know what the intent is, but really, and that's the reason for my language that I brought forward, which I hope tightens that up, subject to your opinion, of course, the opinion of the committee as well, so that if someone, to take a look at the language that I'm proposing, when a defensive driving course, I'm looking at the amendment again, that's in your folder, when a defensive driving course is required by the court or the prosecutor having jurisdiction, because a prosecutor in some circuits could be a DA, it could be a solicitor, depending on where you are, having jurisdiction over misdemeanor traffic law offenses, such course shall be certified and approved by the department under the provisions 40-5-82 and 83. Certificates of completion from unlicensed defensive driving courses shall not be recognized for any purpose under this article. So that I think that's where it gets you where you want to be, while still understanding that it could be I guess it could be court ordered technically, but as a practical matter, it's really prosecutor driven. Are you comfortable with that language, Mr. Chairman?
Yes, I am comfortable with it. I've had the opportunity to speak with the Municipal Court Judges Association representative, and they brought that to light, and we weren't able to get that in the sub I did, but I'm glad you had the opportunity to reformat the words.
Ms. Travis, just in time, just gave us a good lesson in grammar. I think what we wanted to say at the beginning there was when as opposed to where.
That's probably true.
So is there objection on making that small amendment to that change? I mean, to the proposed language? We'll just go ahead and substitute that in. Mr. Franklin, I'm going to recognize you to go ahead and speak to your substitute. What I'd like to do first is to go ahead and see if any members of the committee have any questions of the author, then invite testimony, speaking to whatever language folks want to speak to, and then you'll be recognized for your substitute. Okay. Any questions for the author?
Thank you, Mr. Chairman. I just had a question on your amendment.
Sure.
Under what, I guess I'm just concerned, when can a prosecutor require the taking of a defensive driving course? Isn't that an adjudication by the court no matter who calls it? I just don't know.
My understanding from the conversations I've had in the last day or two with prosecutors is that really a pretrial diversion program is, it's a prosecutor-driven situation. It's not necessarily where it's really before you get to the judge.
Okay.
It's where you've got the indictment and or the accusation. Of course, and my understanding is in a traffic law context, the ticket is the accusation.
Right.
So it's something that you would go ahead and engage with the prosecutor. They'll take a look at you, take a look at your record, and then see if you're eligible for, in their minds, under their discretion, I understand, for that kind of diversion program. You go ahead and complete it. the court will certainly know that, when the case is ultimately adjudicated. It's all part of the file. But as I understand it from the prosecutors that I've talked to, it's not really court-driven. It's prosecutor-driven in their discretion.
Thank you. I appreciate it.
Yeah, sure. Questions for the author? Mr. Knox.
It's basically a pretrial probation arrangement that you enter into, but it made me reminded me of something. We have something coming to this committee to restrict the prosecutors or the judges' authority to. It might impinge on this, is what I'm saying. The bill that I've seen that we may be in front of us. Might want to just look at that and be sure.
Which bill are you speaking of?
I can't think of the number. I know the author, but I'm not going to use his name in vain, so I won't mention it. But anyway, I can tell you later. But
yeah, I mean, if we have a conflict, we'll
right.
As the process goes on, we'll fix it just so we don't endanger either one of them, frankly. Okay, Chairman Rice, thank you so much.
Thank you. Members of the committee, appreciate your favorable consideration.
Barry Schrank with Taggart's Driving School.
Mr. Chairman, ladies and gentlemen of the committee.
Any questions for Mr. Schrank? Seeing none, thank you, sir. Vice Chair has pointed out to me, and I apologize for not seeing him. He's very cleverly hidden. Judge Lawton Stevens, Superior Court Judge. Thank you, Judge, for being here. We appreciate your presence. It's a very safe place you're in, by the way. Skin Edge on behalf of the Municipal Court Judges.
Mr. Chairman, members of the committee, I'll be brief. We understand Chairman Rice's intent, and we appreciate him working with us and other district parties to make sure that the language captures that, and we think it does, and we support the bill with the changes that the chairman suggested.
Any questions for Mr. Edge? Seeing none, thank you. Mr. Rob Miller.
Yes. I thought Representative Franklin was going to present his substitution. I would like to testify to his substitution.
Well, we generally have our witnesses all in a row on a bill, and then a substitute will go ahead and be presented afterwards. But you're recognized if you'd like to.
Yeah, thank you.
Sure.
Not used to getting such an early jump in here. I'm Rob Miller. I'm a citizen lobbyist. Hello, Charlize. She's my rep. So I just wanted to speak to my right as a free man, as a self-governing individual, to travel unencumbered and to be free. I think a fundamental of freedom is the ability to move around. And as such, if I'm in my own property, my own vehicle, and I'm stopped, or the state issuing a license to begin with takes the supposition that the right to travel is not granted to me by God, that my right to be free is not granted to me by God, but is granted to me then by the state. So I have a problem with the whole idea of a state-issued driver's license for me. But then above and beyond that, if the State Department that issued me my license did such a poor job in issuing me my license that they missed the fact that I'm a terrible driver, what guarantee are they offering that in licensing these schools they're going to do any better job? Perhaps private industry would be better left alone.
Thank you.
Thank you.
All right. I don't see any further witnesses on House Bill 538. Mr. Franklin, let me recognize you to speak to your substitute. And again, Mr. Franklin's substitute is LC 342385S, as in Sam.
Thank you, Mr. Chairman.
Oh, sorry.
Thank you. If whenever we look at bills, I know we get a lot of them coming across our desks, and sometimes it's good to ask, well, why are we doing this? What is the history behind the underlying issue in this particular piece of legislation? And I started asking that question even about driver's licenses after we dealt with some driver's license issues a year or two ago in this committee, and started trying to do some research and to find where did this come from. I remember my mother talking about her father, who was a county clerk somewhere in Texas. No one had driver's licenses when he was driving, and they instituted them out there. And because he was an employee of the county, he was not required to have one because he couldn't parallel park. So they just left him about a space and a half to 2 car length space on the curb outside the courthouse designated for him, since they knew he couldn't park. But he never had to get a driver's license. And started thinking, well, why do we have this? What is the history behind licensing and so forth? And I remember I quoted Will Grigg when we first heard this, that a license of any sort, of course, is a government-issued document that transmutes an innate individual right into a state-conferred and state-revocable privilege. And that's offensive, that we do this. Is that really why we're here? We know when our founding fathers gave us that unanimous declaration in 1776, they said that they acknowledged that all men are created equal. They're endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, and that to secure these rights, governments are instituted among men. So the only reason we're here as civil government is to preserve, protect, and defend the God-given rights to life, liberty, and property from those who infringe upon same. So what I've got here in the substitute is some findings of fact going all the way back to Magna Carta about the freedom, the inalienable God-given right to travel, and even going back to some court cases saying that we have that, which you'll see starting on line 28. And so based on these facts of our inalienable God-given right to travel, Section 2 is the meat of the bill of the substitute, which then repeals Chapter 5 of Title 10 relating to driver's licenses. So it's plain and simple.
Questions for Mr. Franklin on the substitute? Seeing none, what I'll do is I'll entertain a motion right now on the Franklin substitute. There is a motion by Mr. Franklin on the Franklin substitute. Is there a second? Is there a second? All right, the motion fails for lack of a second. The question then occurs, what I'd like to do is to have this language that's been prepared. It's in the form of an amendment right now, but it would have the correction when a defensive driving course is pointed out by counsel. Thank you. And I think just probably the cleanest thing to do, Ms. Travis, is just to have that in the context of a substitute. All right. Is there a motion to adopt the committee substitute in this form? There's no formal number on it. Oh, I'm sorry. Not at all.
Two questions. One, first thing, if someone receives a misdemeanor now for this, are they required to go to a defensive driving course?
My understanding, subject to being corrected, is that a defensive driving course is something that is prosecutor-driven prior. It could be court-driven. In other words, it could be part of a sentence. It could be part of what's called a pretrial diversion program, where the prosecutor in your county would be the solicitor, takes a look at this record, the driver's record. The driver says, I want to go into to do a defensive driving program in order to have the charge reduced in some way, shape, or form, I would assume. The prosecutor will then agree or disagree to go ahead and do that. So generally, my understanding, having spoken with some prosecutors and judges over the last day or two, is that generally it's really prosecutor-driven. It's something that the prosecutor and the driver agreed to ahead of time before it even gets to the court.
Okay, so then follow up. If this is a misdemeanor, does this now mean if we were to pass this piece of this bill, that it would be mandated now that they would have a minimum of a driving defensive course or a defensive driving course?
No, it simply my understanding of what we're doing here and what Chairman Rice's intention here is that where a defensive driving course is required, either by the court or where the individual goes into a pretrial diversion program as per the discretion of the prosecutor, that such course must be approved by the Department of Driver Services. Doesn't mean that a course is automatically mandated. It means that if a course is going to occur, whether it's ordered by the court or ordered by the prosecutor as part of a pretrial diversion program, then that course must be approved by DDS.
Okay, so if I decided I wanted to open a driving school, a defensive driving school, there must be some sort of minimum standards that I have to open. I mean, to have this driving course. Now, for the license part of it, so DDS is the one who makes the determination whether you get the license or not.
You mean on running a defensive driving school?
Correct.
That is my understanding.
Okay, now, Representative Rice said that they're out of 5 schools right now, there's only one that's been licensed.
Let me back up a second. In terms of opening the school itself, I guess if you want to just open up a school, you could open up a school. But in terms of having the certificate that's issued by that school mean something, the completion certificate, then under this bill, it would have to be certified and approved by DDS. So the technical answer is, I guess someone could open up a driving school, but in order for that certificate after a defensive driving course is taken to mean anything, it'd have to be a school that was certified by DDS. Correct? Okay.
So then, with the one school that's licensed, anytime someone is required to go to this defensive driving course, it will have to go through that one school. No. Okay. Thank you.
Yes, ma'am. Mr. Franklin.
Chairman, even with this, I'm still somewhat concerned that even though we use the word certified and approved, that's still basically a license by another name. And if we do nothing, we still have the on the original language, which is any driver improvement program to which attendance is required by court order shall conform to the requirements of this article. If we do not adopt this and vote it down, then the free market then gets to determine which school is valid. Even in the example that Chairman Rice gave us, the court provided the list and had those particular schools on it. There are probably some that are available that the court did not offer as a choice to those that were being required to take it. So I'm very cautious. I do think the free market would be a better solution here.
Thank you. Mr. Hatfield.
Mr. Chairman, I'd just like to add, I think, and I'm not trying to put words in Representative Rice's mouth, but I think what he's trying to get at is to make sure that when a person goes through a course and it is presented to a court as part of a plea agreement, part of a pretrial diversion, that we make sure that whatever course that person has taken meets certain minimum requirements, because otherwise, and I don't think there's anything in this or in the law generally that would prevent somebody from just opening up a defensive driving school if they wanted to, but the point is that, if you just have Billy Bob's defensive driving school, that Billy Bob might not necessarily have met all the criteria that we would want them to meet in order to make sure that the person has satisfied the objectives that would be a concern for public safety. Representative Rice, is that kind of putting it in?
Sure.
We're
going to dismiss the ticket. The law is engaged when you have the ticket. There ought to be a criteria by which that's done. The criteria ought to be clear, and it ought to be auditable which is what DDS does for the schools that are under its auspices.
Now, would a private school that opens up have the opportunity to petition DDS to authorize them?
There's 300 schools that are already on the list.
Okay, and those are statewide, is that right?
300. Ms. Travis. Well said, Mr. Vice Chairman. Thank you. Ms. Travis, you had a concern?
Yeah, I'm sorry.
No.
But kind of backing up to what Representative Abrams had to say about the prosecutors, and two things occur to me. One is I think the proper term is prosecuting attorney. We don't really use prosecutor.
Okay.
The second thing is that it says required by the court or the prosecutor having jurisdiction over misdemeanor traffic law offenses. I think the court has jurisdiction, but I don't think a prosecutor actually has jurisdiction. I think the prosecutor runs the pretrial diversion program. So I think the sentence.
You had two different contexts, one in terms of a court order, one in terms of, in a different circumstance, if it were under the context of a pretrial diversion program.
Right.
Okay.
So I think maybe if we said the sentence, when a defensive driving course is required by the court having jurisdiction over misdemeanor traffic law offenses, or the prosecuting attorney involved in any pretrial diversion program or running any pretrial diversion program, I'm not
Sure.
exactly if there's a solicitor here that could.
I mean, I think, stylistically, I mean, that's a choice, but your point being that you've got two separate contexts. I agree. Do you want to try to hash out some language now, or?
I know because the thing about pretrial diversion programs, in some ports they're on the front end and some ports are on the back end. And I don't really think that matters for purposes of our language, but running is not the right word.
Yeah. Mr. Hatfield.
What about if using the chairman's amendment, when a defensive driving course is required by a court having jurisdiction over misdemeanor traffic law offenses or any prosecuting attorney thereof?
Let me ask Mr. Hatfield to read that back again, just so everybody's got clarity.
When a defensive driving course is required by a court having jurisdiction over misdemeanor traffic law offenses or any prosecuting attorney thereof, comma, such course shall.
Ms. Abrams.
Just make one scrivener's error, change or by any prosecuting attorney thereof, because you've got the prosecuting attorney coming after the traffic law offenses. So,
Just adding the word by, just to make sure we've got two separate contexts.
Right.
Yeah. You got that, Ms. Travis? All right. I'm going to ask you to prove it and read it back to us.
When a defensive driving course is required by a court having jurisdiction over misdemeanor traffic law offenses or by any prosecuting attorney thereof, comma, such course shall be certified and approved by the department under the provisions of Code Sections 40-5-82 and 40-5-83.
Well,
And the last sentence remains the same.
all right. I don't think I ever took a motion actually on the initial language as a substitute. Let me ask for a motion. Let me first ask for a motion. Is there a second? There's a motion and a second. We've then got an amendment by Mr. Hatfield and Ms. Abrams that Ms. Travis has just read back. Is there any objection to the amendment? Hearing none, the amendment's adopted. Any further amendments? No. Okay. Hold this. Any further discussion? Okay. On the gentleman's motion of do pass by substitute as amended of House Bill 538, all in favor say aye. Aye. Opposed? No. The ayes have it, and the motion is adopted. Chairman Rice, thank you.
Thank you, members. Are you ready?
We'll move on to Senate Bill 136 by Senator Douglas. Sorry? I thought you pulled that bill, Chairman. Oh, no. We recall that we looked at Senate Bill 136 in the summer, sort of an initial pass at it. and to talk about a few issues. I thought it was timely to go ahead and bring that up again. There's not been a whole lot of conversation that I've experienced on it in the interim. My sense is that there's some additional testimony here today. Senator Douglas, if you would, in a nutshell, just sort of let us know where you're going, with it, what the intent is, what the voluntary, involuntary nature of the proposed action is, and then if you have any proposed changes as a result of conversations, or proposed conceptual changes anyway, that you have as a result of conversations that you've had between the summer and now, if you wouldn't mind sharing those with us, and then we'll march on from there.
Mr. Chairman, thank you for hearing this bill again so early in the session. I appreciate the chance to come in front of your committee without a methamphetamine bill that hopefully we can get a little more consensus on. Your subcommittee chairman did a great job, by the way. This is SB 136, and what this does in a nutshell is it brings the state into compliance with the federal Immigration Control and Enforcement, ICE, rapid removal of eligible parolees accepted for transfer, or the acronym REPAT program. This is a program that's paid for by the federal government, and it relieves Georgia taxpayers of the burden of housing and supporting illegal aliens who have broken other laws in this state besides being here illegally. Rather than releasing convicted criminals back onto our streets when they're eligible for parole, this program would provide for their voluntary deportation back to their home countries for release there. Participation in the REPAT program, as I just said, for eligible criminals is voluntary. There is no forced repatriation in this program. They must agree in writing to participate. They must agree in writing to abide by the immigration laws of this country and not return to the U.S. illegally once they are returned to another country. Should they agree to those terms and become eligible for normal parole in the Georgia prison system, they can be selected for transfer to the federal prison system for immediate deportation. Any person that participates in the program and then returns to Georgia illegally and is recaptured would be required to go back and serve the original punishment. This is a bill, ladies and gentlemen, that I want to reemphasize a couple of things. It's voluntary, and it is paid for by the federal government. With that, Mr. Chairman, I'll be happy to look at the bill. One of the concerns that has come up is that throughout the bill we use the term alien prisoners, or we use the term alien. I think that we need to clarify that, perhaps by perhaps saying illegal aliens or some other term that would clarify, because we have legal aliens in this country, and I don't think any of us have an argument with having legal people that come here legally. Personally, it, with me, is a fine thing, because many of our people came here that way. My ancestors certainly did. So I think we need to annotate on here in a committee substitute or as an amendment the word illegal. I would recommend the word illegal in front of the word alien through the bill. And I've gone through, and I'll work with legislative counsel on that, but I've gone through and annotated this one to ensure that the bill specifically says illegal aliens are the people we're dealing with here.
Well, we need to go ahead and define it. I mean, we need a definition of alien, and I mean that's
we could work
under the bill.
We'll work with legislative counsel on that, Mr. Chairman. There may be a definition in the law already for illegal alien that we can just incorporate into the bill. Questions for the author, Mr. Levitas?
Thank you, and thank you, Mr. Chairman, for bringing this bill. Just a couple of quick questions, and I apologize for not having picked it up in the bill. Which line is it that talks about the offense of reentering the state after being deported? And I apologize for not picking that up in the bill.
That is, stand by.
Oh, here we are. I think I found it. It's any such alien who is convicted of an offense in the state after returning to this country shall serve the entire remainder of his or her sentence without parole.
Right.
Did you consider at any time about making that a separate offense? In other words, reentry, making it a separate offense, not only serving out the remainder, but if the only punishment for reentry is serving out the remainder, did you consider maybe making that an additional offense, reentering as a...
I don't know. Representative Levitas, that's a light code section, and that's that's germane to the bill. So So that actually was put into the bill when it was in my committee. That was not in the original bill. It was put into the bill as an amendment in my committee. So the answer to your question is no, we haven't thought about making it a separate bill, and I think that the pardon and parole folks are here to talk about that and related subjects and how we might further amend the bill to relieve a little bit of the pressure off of them that this version of the bill puts on them. So if you may want to wait and hold that
Yes, sir.
for them when they come up.
And just one more question, and I have a feeling this may be part of the federal guidelines for it. Is there a reason we made this a voluntary program?
Because it's voluntary under federal law.
Okay. And are we not able to make it mandatory because of the federal law? If they preempted this,
I think that's a bill for another day. I personally would support that, but that may be for another bill another day.
Okay. Thank you, Mr. Chairman.
Yes, sir, Mr. Franklin.
Thank you, Mr. Chairman. I applaud the senator for the motives of particularly trying to save our Georgia taxpayers, and that's very important to us.
Although we sometimes forget that federal dollars come from our pockets as well.
Yeah, absolutely, and I'm certain you are familiar with Article 4, Section 4 of the Constitution of the United States, that says in part, the United States shall guarantee to every state of this union a republican form of government and shall protect each of them against invasion. And they have definitely fallen down on the job, I believe, of protecting us from that invasion. And they definitely.
I think we're waxing philosophical here, Representative Franklin. I agree with you, but I don't know that that's part of my bill here.
I think it's probably
it's the reason we have the bill.
Exactly.
Yeah.
And I think since they have fallen down on the job, the financial burden definitely needs to be theirs in dealing with it. But I know the states created the federal government, and they are agents. The federal government is an agent of the states. We are not an agent of them. Have you done any thought of possibly, instead of doing this repat program, of just sending them to once we capture someone that's determined to be in the country illegally that's committed a crime in Georgia, either transport them to D.C. or to the front gate of the nearest federal penitentiary in the state?
Well, I appreciate your thoughts, and unfortunately, we don't have that I know of have the ability to deport somebody over to Alabama, for example, to get them out of Georgia, or to Washington D.C. for that matter. So this is a federal repat is a federal. It's not a state program. It's a federal program. So we're just putting the state in line with that. Repat is not our program, but it behooves us to get involved and become a part of repat, and that's why I'm here today. As much as I'd like to deport people to Alabama, Representative Franklin, I don't think we can do that.
Ms. Benfield.
Thank you. I have several questions, but I think they're all quick ones. First of all, repat, when did that pass at the federal level?
I don't know the answer to that. Maybe somebody else can answer that. All I know is that it's in effect now.
2008. And does the federal law, does it mandate that the states pass a law such as yours
states can apparently have the right to volunteer to participate because we're not in it right now.
And does a state have to pass local or state enabling legislation in order to take part in repat? Is this bill or something like it necessary in order for us to be part of repat?
I think that I'll have to defer that to Legislative Council, but I think in order for us to ensure that we are a part of it, this is the way to do it.
Can I get confirmation of that from Leg Council? Oh.
We can easily find that.
I think the key here, Representative Benefield, is that again, if we want to make sure that we take part in the program, we need to use this avenue to do it.
And last question is the funding. It says funded and operated by the U.S. government. So this program would be fully funded by the feds, or would there be any cost to the state to implement this?
The costs are picked up by the federal government.
Okay. Thank you.
That's all I see. Senator, thank you.
Thank you, Mr. Chairman. I appreciate it. I'll move aside here for your other commenters.
Okay. In the order that they signed up. Sure. Mr. Franklin.
That just raised a question, Representative Benfield's question did, and that's something like we saw with Peach Care. What happens with the federal government stops funding this? Then are we on the hook for any expenditure?
Representative
now that we've got it in code, and then the illegal alien voluntarily decides to participate in the program, what type of financial obligation are we under?
I'm not going to sit here and pretend to predict what the federal government's going to do because, like you, I believe they're out of control.
Mm-hmm.
And so whether they do or do not keep this program is not something that I can sit here and predict. But once we put the program into statute, we can take it out of statute. We can repeal the program if necessary later on. But for the time being, while the federal government is, at least for the time being, doing this, I think we need to participate.
Thank you.
Inger Eberhardt. Inger Eberhardt, on behalf of the Dustin Inman Society.
Good afternoon. I'm Inger Eberhard, and I'm a member of the Dustin Inman Society Board of Advisors and a native Atlantan. And Senator Douglas's bill is aimed at saving Georgia taxpayer dollars, presently going to pay for the imprisonment of illegal aliens who committed crimes in addition to illegal entry into our nation. And the federal REPAT program offers release and removal to nonviolent and legal alien offenders. And I just want to say that we're in support of this bill, and it will save Georgia taxpayers money by deporting those who should not be here. And I just wanted to urge you to vote yes in support of SB 136, Senator Douglas's bill.
Ms. Benfield.
Just a quick question. I didn't make out the name of your organization. If you could just tell me what your organization does. I'm not familiar with it.
The Dustin Inman Society, and what we do is we're against illegal immigration and illegal employment, and we want secure borders.
Thank you.
I see no more questions. Thank you. Mr. Larry Pellegrini, on behalf of the Georgia Latino Alliance for Human Rights.
Afternoon, Mr. Chairman, members of the committee. I'm sorry we were unaware in following this bill in the past that there were any interim hearings, so some of the information I have may, I hope, lead the committee to reevaluate either by study or in collaboration with counsel. As we heard, part of the purpose of the bill was to become a part of the REPAT program. We aren't in it right now, and we need to participate, but actually there is a memorandum of understanding for REPAT that Georgia signed on October 3rd of 2008, and I believe as written the bill conflicts with that memorandum in a couple of cases. Being a part of the REPAT program really is not what I would be talking about in rewriting the bill. We really feel there's no need for it since REPAT is already a memorandum of understanding, and after passing any language would have to go back for REPAT MOU. One of the things that conflicts is that the bill uses language that appears to take the authority of a federal judge in issuing final deportation orders and initiates the process before that's happened. And REPAT requires that it be after that happens.
Would you repeat that and point that out where in the bill you're referring?
Yeah. In Section D, the department shall obtain the final removal order, and under REPAT, my understanding of the MOU is that they send the federal immigration judge's final deportation order to us. So that would sort of be backwards. And in
Yeah, I think he's at line 2. I mean, page 2, line 49.
I'm sorry, I have the by section, but not the by line.
Could I ask you a question related to that, or did you want to get into other things first, or you want to ask questions as we go, and then we'll open it up as well?
Either way, so.
Okay. I mean, what I just heard is that under this program, there's currently a memorandum of understanding
with Georgia to get into the repat
between the Department of Corrections
and the state, on behalf of the Department of Corrections, the state of Georgia.
The state of Georgia, and what entity of the federal government?
ICE.
Okay. That memorandum of understanding, that MOU, is, of course, fragile in that the state could withdraw from that MOU at any time, correct?
Yes, I believe so.
Okay, and by virtue of not being codified, Georgia's not locked into that position. It could come and go with the whim of a particular administration. Is that a fair statement?
But without renegotiation, they would not fund it. And already there have been over 3,000 subjects that have been repatted under the program.
So your point, if I understand it correctly, and I'm just trying to make sure that I do, is that if we were to go ahead and pass a bill such as this, it would obviously invalidate the existing MOU, and that as a result, the state of Georgia would have to finalize an additional MOU with the federal government.
Yeah, my understanding is it would require going back for agreement.
Right. Why is that a terrible thing?
Oh, I'm not saying it is. I'm saying as written, there are a couple of conflicts.
Okay.
This isn't about immigration or repat. It's about the bill and what it appears to conflict in that program.
Okay, and I'm just trying to understand the conflicts, because this is just not something that we look at every day.
Oh, no, I understand. And it's very difficult to find the entire memorandum. You'll find summaries, but it's difficult to find the entire memorandum to compare item by item.
In looking at the lines that you just talked about before, following approval for conditional deportation, parole from the board, the department shall obtain the final removal order. I read that to mean that the department shall obtain, meaning receive from the federal judge or whatever adjudicating authority it is, that removal order, as opposed to, I think it's more of a receipt of that order as opposed to taking on some sort of role that doesn't belong to it.
It appeared in this context to be one, and if pardons and paroles is here or Department of Corrections is here, we might find out how it's been applied. But it appears here that they are the active party in seeking. That's something that can be clarified, but that appears to be a conflict.
Mr. Douglas?
That's actually correct. They would be seeking the removal order because the state has to be the proactive party here in order to seek the removal order and notify the federal government that, hey, we've got, Joe Smith here ready to go, and all we're waiting on is the paperwork, and as soon as you send that, we'll send him to you. And I mean, that's what it says here.
Right. I mean, that's the nature of the obtaining under the statute as I read it. I just want to make sure I'm not reading it incorrectly.
But my understanding also is that that the MOU for repat is that they notify when they have completed an order, and the state can then take advantage. So if I'm wrong, we can hear from the department on how it's been applied, but I believe that's the way it is. So that's why I'm saying it appears to be in conflict.
Okay. I mean, I read that just to be sort of a logistical.
But still, the way it's written, would.
Okay.
That's all I'm pointing out.
Fair enough.
Not debating.
No. Me neither. I'm just trying to understand the nature of your perception of an existing conflict.
Yeah.
Did you want to make any other statements before I open it up?
In addition, Section F, and let's see if I can quickly find the line here. At the end of line 57, page 2, prior to granting parole conditioned on deportation, the alien must also make a knowing, voluntary, and intelligent waiver in writing of all rights of extradition, right to parole, revocation hearing. I believe that the Memorandum of Understanding requires that that be in a certain format so that the person can, so it can be proven that it was knowing, involuntary, and intelligent. So it really needs to be clear if this is accompanying parallel legislation that doesn't conflict, that it's clear that the person is notified and has an understanding that they can receive the help of an immigration attorney at no cost to the state.
And you're saying that's a federal requirement. In other words, for us to go and implement something like this under the knowing, voluntary, and intelligent, there are federal requirements as to what actually constitutes knowing, voluntary, and intelligent. Is that a correct statement?
I believe so.
Okay.
And that should be stipulated in the language here so that the qualifying statement will be achievable, that we know that the person would have made their decision knowingly and voluntarily and intelligently.
If any, I mean, correct me if I'm wrong. If anything, that probably actually, step out for a second. That may actually even strengthen the bill because it does, but there are probably, to Mr. Pellegrini's point, there are probably very specific federal requirements that have to be adhered to the T, or else that affidavit gets disqualified, in which case you're back to square one. It seems to me that assuming that procedure exists, adhering to that procedure, frankly, fortifies the state in making the assertion that, yes, we did everything right, cross the T's and dot the I's, and here's how. So that's just a comment, not an editorialization on it. Mr. Everson. Mr. Lunsford, sorry.
Thank you, Mr. Chairman. I just want to point out that actually the state entered into that contract in October of 2008 as one of the model states with the federal government, and it's worked pretty well. We've removed 3,612 criminal aliens so far from the prison system. Now, keep in mind that this program, when you're talking about your definition of alien, I'm not sure it's really relevant because it only applies to criminal aliens. This code section would only apply to criminal aliens incarcerated under the repat program, which means they already had to be determined to voluntarily be repatronized to their home country if they so choose to serve out the balance of their term there. So when we address the issue of the legislation not being needed, actually the federal code is really clear, and what it says is that, if you'll bear with me for just a second, that state statutes must provide for revocation of parole and confinement for the remainder of the alien's original sentence. Additionally, aliens may be prosecuted under federal statutes that provide for up to 20 years in prison for illegally reentering into the United States. So they're clearly stating that we have to enact a state statute to correspond with the repat program. So I respectfully kind of disagree with him on that. And they're actually stating that it has to be a written, voluntary submission by that. Maybe we could fix the legislation by saying that the voluntary part has to be in total compliance with repat, and that solves that whole problem, sir.
Ms. Abrams.
And this may be a question for a later time, but I shared Mr. Pellegrini's concerns because I've worked on MOUs that have been vitiated by subsequent statutes, which do render you ineligible for funding if you violated the terms of the MOU, depending on the provisions. My question to Senator Douglas, if it's appropriate, is to find out if there has been a conversation where they've matched this legislation with the MOU to make sure that we don't violate those terms, because at any moment of violation, there's the possibility that you essentially suspend the ability of the state to receive reparations for any of the deportations and for any part of the process. And so I do think it's very important to make sure that we've reconciled the law to the MOU, because to your point, yes, the moment you do codify this, you supersede the MOU and render the MOU invalid to the extent that it's not consistent. And
your comment goes to having, I don't know how this actually logistically gets done, in a conversation, a meeting, an informal MOU prior to the passage and signing of this bill, which would constitute a new MOU in order to have a seamless transition between what was previous to a statute and then the implementation of a statute without having that gap period whereby we could lose that funding.
Our MOUs with the federal government are contracts, and it essentially sets the conditions under which they will reimburse us for any services provided. And so my concern is that if we haven't reconciled this, we run the risk of, for those 3,600, if anyone's in process, if we are not abiding by the terms of our MOU, we create an opportunity for the federal government to refuse to refund those dollars.
A follow-up question then to the author, maybe to Mr. Lunsford, who I know is familiar with it. I mean, is there a mechanism within the federal law whereby if a state does pass a statute such as this, that there would be a seamless transition between what ends up being one contract to another one?
Right. And just to add information to this, I think it was Congressman Price who actually was the co-author of the bill. And so I think we were one of the first states to enter into the contract, and so we would be less of a test case because most states that are doing this have followed the process differently. We were the state that helped bring the law into effect, and so we immediately entered into those contracts. We're now going back and codifying, and most states are codifying first and then entering into the MOU. So I don't know that there would be an example of a state that would be in the position we would be in by passing this law.
And that's my question: does that mechanism exist so that we don't find ourselves in that gap situation that Mr. Okay, Ms. Benfield.
Thank you. Along those same lines, I think I'd like to see maybe a printout of the relevant provision that Representative Lunsford read, because I wasn't entirely clear if the existing code already in Georgia allows for revocation hearings in deportation cases. So I just would need to see if obviously we've already deported some 3,612, I think is what you said, undocumented immigrants. So the law, it's already working. So I question whether it's necessary that we do enact this into law. And I don't know the answer to that, but I share the same concerns that we certainly don't want to risk losing federal funding. And I do have just a couple more.
Well, the MOU,
questions.
just to get into that point, I mean, the MOU itself, that to my question earlier, that MOU can be rescinded at any time by the state. Is that a
And we want a seamless transition is what we want.
That's correct, Mr. Chairman. And the MOU also doesn't carry the force of law in the fact that if somebody comes back into the country illegally and is recaptured in Georgia after they've been deported under the provisions of the MOU, there are no provisions under Georgia law right now for any sort of punitive type punishment or that sort of thing, as might be covered in this statute. So that's another reason why I think the statute is necessary, because there's nothing to keep somebody from coming back in the country illegally and coming right back to Georgia after they've gone through this whole pipeline.
Okay, let me, Ms. Pellegrini, Ms. Benfield had the floor. Let me go ahead and have her complete her line of questioning. Then, to the extent that you respond to any of her questions, you may want to go ahead and follow up on a point that you're probably dying to make.
Yeah, well, and I think Representative Abrams is probably putting her request to speak in, but that's federal law that we're getting into with immigration, revocations, and all that, so that's not anything that we could dictate in state law anyway. But I did have a couple more questions that kind of occurred to me as we were going over it. On page 2, on line 58, with regard to the knowing, voluntary, and intelligent, does that bring along with it a right to a translator? Is this because many of these individuals do not speak English, so are we mandated to require, or I guess the federal authorities would be providing a translator, but are we putting in here a requirement that we make sure that there's a translator? And I mean, some of these jurisdictions, we may be hard pressed to find a translator who speaks certain languages.
Do you want to answer that, Mr. President?
Part of the intent and application of the REPAT program is that an immigration attorney who would have the language skills to deal specifically with the country of origin's language. So they provide for it. That's at no cost to the state.
Okay. And if I could just ask one more, and this is more for my own erudition, I think I understand this, but it says, let's see, line 40, well, I guess lines 39 and 40 on page 2, it talks about the department identifies aliens eligible for deportation. So I'm assuming we're looking at only persons who've been convicted of felonies. So this would only be felony offenses if it's within the jurisdiction of the Department of Corrections. I'm just wondering if folks who've been convicted of, say, a misdemeanor offense would fall under this jurisdiction as well.
It would be nonviolent.
So is that nonviolent felonies? So, but not nonviolent misdemeanors. These.
Yeah, correct. They would not have parole.
Yeah. So I mean, I just want to make sure because, and certainly also the Department of Corrections, I think it would only be felony offenses. So, okay.
Mr. Lunsford.
Yes, sir, Mr. Chairman. I just wanted to clarify. I think we're kind of putting the cart in front of the horse a little bit. The REPAT program is a federal program. We can't change any structure of that. And what Senator Douglas is trying to do with his legislation is do exactly what the federal government mandates us to do. What the federal government is saying is if you participate in the program and we give them early release back to their country of origin, then in the event that they return to your state, you must provide for revocation of their parole and for confinement for the remainder of their term because they were getting a light treatment by then letting them go and go home. But it's totally voluntary, and it is all nonviolent criminals. If it's a murderer or whatever, he's not going to get this release from the federal government. But that's all determinations they make. The release is a determination they make. People that are eligible is a determination they make. All that we're trying to do with this bill, which I think is a wonderful piece of legislation, I wish you'd let me read it before he brought it, is we're doing what the federal government mandates that we must do, and we must provide for revocation of the parole and for what we gave them from the state, because we let them out of some of the state charges to participate in the federal program. And it says quite clearly on the REPAT website on the requirements of the state, and it says that state statutes must provide for revocation of parole and confinement for the remainder of the alien's original sentence. Additionally, aliens may be prosecuted under federal statutes that provide for up to 20 years in prison if illegally returning to the United States. But they don't give us an option. That is our responsibility as a state for participating in the program and then kind of pulling them out of our prison and saving us the money. And so with that said, Mr. Chairman, a lot of the stuff about the interpreters and all that stuff doesn't really fall in our purview. That's all federal stuff.
I appreciate the comment. Let me just make sure.
Yes, sir.
And I understand the mandate. If you want to go ahead and I understand that it's established federal law. If the state were to go ahead and participate in that program,
right,
there's a certain protocol that goes along with it, again, as per federal law.
Correct.
I guess the only thing logistical I could think of concerned would be by virtue of our passing the statute, do we get into Ms. Abrams' point about threatening the seamlessness between the existing MOU and any subsequent MOU? In other words, we pass the statute, does that render the first MOU meaningless?
Who knows? And
then it might be worth doing so that we could know exactly what the consequences of our action are, if for no other reason, just so we don't have a gap between where we are currently and where we want to be as per the federal statute.
Yes, sir.
But between the time of that second MOU, assuming a second MOU has to be executed, is actually finalized. That's my only concern, so that we don't have this area of time between the two where nothing's happening and or we're on the line for those funds.
Yes, sir. At the appropriate time.
You know what I'm saying?
I have an amendment as well at the appropriate time.
Well, it's going to be not this meeting. I guarantee you that. Ms. Abrams, then Mr. Levitas.
Actually, I think Ms. Benfield and you both made my points.
Okay. And I'm looking at it from the context of making sure it works.
Absolutely.
Because I think from a conceptual standpoint, look, it's existing federal law. Let's just make sure, that we're addressing here. Let's just make sure that it physically works if and when it's implemented here. Let me ask Mr. Levitas and then Senator. Okay. Mr. Levitas.
This is just, I guess, a question of clarification for the chair.
Yeah.
I mean, if we're going to go back and examine the MOU or this effect on the MOU, does it make sense to go ahead and perfect the bill according to what the committee wants and then run that by to find out whether that would fit within the existing MOU, or whether we have to get and if we do have to get another one, to get one?
And it almost goes to the issue of, do we have to get some sort of pre-clearance, on this type of thing, or would we be wise to do that logistically? And the short answer to that is I don't know. But I think it's worth asking someone who may know,
Right.
you know,
And
the
I guess
question. I really don't know, but that.
My only question would be, if the answer to that is yes, it would, you know, I would just ask the chair whether we shouldn't go ahead at that time, get the bill in whatever final form, including all amendments we think is right, and then find out if we need to have a, you know, what the MOU would be.
Sure, that's perfectly reasonable.
Thank you, Mr. Chair.
Mr. Pellegrini, do you have anything further?
I was just going to clarify
Sure.
when the statement was made about there's nothing to prevent a person from coming back. That is federal law, and Representative Lunsford was correct. That does have a penalty of up to 20 years. But also in
let me interrupt you for 1 second. That's a 20-year. Is that separate and apart from the
Yes.
revocation of the
Yes.
sentence? And that
Yes.
goes to Mr.
Yes.
Levitas' question earlier
Yes.
about having a.
Yes.
But that is, it's mandated in the federal statute.
Right.
Okay. There would be nothing precluding us from writing an additional penalty as per Mr. Levitas's.
The bill does say that any state offense, they would have to come back and finish the rest of their complete state
Right.
Right.
without parole as well. So the
Right.
state does have some punitive language in here as far as that goes.
Mm-hmm.
Which is a requirement under the repat.
Right.
The state
Right.
can make them finish
Right.
100%.
Understood. But I was just going to Mr. Levitas' question before about an additional penalty beyond that, but then you get into the philosophical issue of more of a burden on the state at that point. You know, that goes to the entire intent of the bill to begin with. So,
Mhm.
okay.
But the reason that for the last couple of years the process had worked is because the state was following without adding anything to the MOU. And as long as it was, and the MOU was permissive, I believe, which is why it would be good to hear what Pardons and Paroles or Department of Corrections says. But I believe it was permissive of them to set up, when they talk about codifying,
Mm-hmm.
if they had something already set up that was already a process for which an individual could get probation for the same kinds of offenses, the nonviolent offenses, that they didn't have to have something new for the department. What they were doing already followed.
Okay. Any further questions from Mr. Pellegrini? Thank you.
Thank you.
Thank you. Mr. Rob Miller.
I'm Rob Miller. I testify on behalf of Life and Liberty, and I want to thank you guys, thank the chair and the committee again for hearing my humble petition. I was concerned with the very first sentence when this bill was presented, that this brings the state into federal compliance. Anything that starts off like that sends a giant red flag up for me personally. I was encouraged, though, by the second sentence, and that was we're going to place the burden of these cases on the federal government. In the spirit of that, and I have to say, the Dustin Inman Society testified a little bit earlier here. They advocated for SB 529, which was another Senate bill that probably came through this committee a couple years ago. I'm not certain. But that bill is a federal mandate as well, and it requires, it's basically a backdoor Real ID Act is what it is. And right now I know it requires that that counties fall in line with certain federal mandates, or the states will cut off the state funding. So there's this MOU that apparently the counties are having trouble with right now to come into compliance with that before they make it so that I have to submit my federal ID before I can buy a gallon of milk in my county. So I really appreciate the stalling and the problem with the MOU between the county and the state right now on that particular issue. To that point, should our sovereign state, and I would like to recommend a reimbursement here that keeps the burden of these cases on the federal government, period. If this is a completely voluntary thing, if these people want to go back home rather than sit in our prisons,
absolutely let them have it. But should our sovereign state lose this reimbursement contract, and this would be my proposed amendment, with the corporation known as the United States of America, or should, for some other reason, this program cease to be directly and completely funded by money seized by that corporation from the citizens of the free state of Georgia, then lines 31 through 68 shall be immediately revoked, and said alien prisoners will be deported to the District of Columbia. I think this is a decent compromise that solves everyone's concerns, and then it just leaves the responsibility on DC. If they're not gonna continue to fund it for us, we just give it to them and let them give the problem to them and let them deal with it. The feds have installed loopholes with these MOUs. If you comply over here, you're out of line over here, so we cut off funding on this. We just install our own little loophole here and say, okay, guys, two can play at this game. After all, we are a free and sovereign state. Why not?
Thank you. All right.
Thank you, guys.
Senator Douglas, I think you've got the gist of some of the concerns that are there that need to be tightened up. Pardons and paroles, neither during the summer meeting nor today, signed up to speak. So they pardons and paroles and any other affected state agency would do well to be a little more communicative on things that affect them. That being said, Mr. Travis? I think at this point, let us go ahead and do a little research, because I haven't heard anything from pardons and paroles over the course of the year about this bill at all. I find that a little troubling. That being said, I think we've got some assignments to do, especially as it relates to our interaction with the federal government and how it's working or not working. Of course, those who are actually doing it and are involved with it probably are the voice of experience, and we're not. So we could either go ahead and, just do this, or we could go ahead and get some communication and guidance from those who are actually living it. That's up to you. Am I communicating? Oh, good. Good. I think what I'd like to do, Senator, is just to sort of step back and to ask counsel to go ahead and tighten up where possible on definitions, and then let's go.
What I was going to say is we want to add a definition of illegal aliens. We want to determine what we're talking about by aliens in here.
Mm-hmm.
So we want to look at the MOU and see what's in the MOU. And then
Oh, I'm sorry. You just wanted to summarize what the issues are. I apologize.
That we want a definition of what aliens are that we're talking about in here, that you and I talked about earlier. That we want to find out the language in the MOU in the event that there is some conflict there.
To Mr. Levitas' point earlier, it would serve us well to take a look at the MOU and to figure out logistically what is the best thing procedurally to do. My sense is that Representative Levitas is right in that we would do well to go ahead and pass out the best statute that we can procedurally, and then engage in any communication with our federal friends to the extent that that's possible, necessary, etc.
I agree, and I think from what Representative Lunsford has read, the federal statute is pretty clear in that area that they expect us to do something, and I think we're on the right track, Mr. Chairman.
Okay. Mr. Lunsford.
Mr. Chairman, I passed that amendment to the committee. I just stuck one in front of you, sir, for your consideration. It's just a friendly amendment, I hope. You certainly may.
You know what? We'll save this for the markup. How about that?
That would be wonderful, Mr.
All right.
Chairman.
Tuck it in my pocket.
Thank you, sir.
Mr. Chairman, I'll get this to Lay Council, and we'll get back to you.
All right. Thank you so much. Ms. Travis, did you have something? I see your light flashing. Oh, Mr. Setzler, I apologize.
Hey, Mr. Chairman, I'd like to make a general sort of urging statement to the committee and to all departments. I mean, I would urge the committee that if there are departments on this bill or any other bill that are invited to come to the table to speak, and for whatever reason choose not to, that I would certainly urge the committee to consider that as a not an oversight or a miss, but a deliberate, intentional decision to not speak and participate in the process. It does concern me with a citizen legislature with a limited term down here for about 3 months, that there's certainly the potential for agencies to take advantage of the timing of the legislative process and let things get late in the session to strengthen negotiating positions, just as a general statement. And it is a concern of mine that this committee process, and in fact our legislature as a whole, is not, or members like Senator Douglas that's looking to bring this bill early in the session don't get in a position where they're kind of over the barrel late in session with language because departments come in late and decide to play the we're gonna disagree late in the game process. And that's not directed at any agency. It's just something that was raised today, and I'm just making that as a general statement and an urging statement to the committee to make sure that we're very clear to departments on a whole variety of bills.
I share the gentleman's concern, and sometimes it really depends on how folks want to be involved or not. Sometimes it could be in the context of, well, we didn't oppose it, or we didn't endorse it, or, well, that's not really our job. And while I certainly respect any agency that will go ahead and say, look, it's not our job to make policy, it's our job to enforce it, we're a pretty inclusive committee, very inclusive committee, in that we welcome the input of those who are actually living it on a day-to-day basis, whether we're talking about defense attorneys, prosecutors, judges, whoever, agency heads, pardons and paroles, corrections, and the list goes on. What I not fear, but the concern that I have is that we put our best foot forward in doing our best to do good public policy in the context of some federal parameters that we cannot do anything about, and then after the fact, folks come and say, well, we wouldn't have done that, and can raise Cain about it afterwards. That's not really constructive. It doesn't help the citizen legislator, as you say, Mr. Setzler. So your point's well taken, and we're just going to put our best foot forward, and we'll take whatever feedback we have, good, bad, and different, and make the best decisions we can. But doing nothing is not an option.
And Mr. Chairman, for what it's worth, I would consider, particularly a bill that's been carried over since the last cycle, I would consider an agency that's not been engaged in the process until late in the game to be in a full agreement. And I take silence as full agreement. And I would just urge agencies to do their homework, come here, and be part of the process.
I'll go one further. Sometimes when you have that amount of time and folks don't stand up and say this is what we think because this is what we do, I consider that almost to be the sin of omission. That's what I think, for whatever that's worth. Mr. Franklin.
You actually addressed in a much better way what I was going to say.
All right. We'll stop there. Thank you for everyone's time and patience, and we're adjourned.